This is English shorthand dictation number 344, and the dictation speed is 120 words per minute. Ready? Start. We have given careful consideration to the submissions. The first respondent urged that it is necessary for the legislature to introduce a law dealing with liability in tort. On the basis of the prayer made by the first respondent, a direction has been issued to the central government to consider introducing of a bill on the subject, and outer limit of 6 months has been fixed by the High Court. As far as the law of torts and liability thereunder of the state is concerned, the law regarding the liability of the state and individuals has been gradually evolved by courts. Some aspects of it find place in statutes already in force. It is a debatable issue whether the law of torts and especially liabilities under the law of torts should be codified by a legislation. A writ court cannot direct the government to consider introducing a particular bill before the House of Legislature within a time frame. Therefore, the first direction issued under the impugned judgment was unwarranted. As regards the second direction, it must be remembered that when a litigant seeks a writ of mandamus, he must show a right existing in his favor and the corresponding obligation of the state to ensure that the litigant is able to exercise the said right. There is no right vested in the applicant to claim that the law commission set up by the central government should be given constitutional or statutory status. 21 law commissions have already functioned and submitted reports. Whether law commission should be given a status under the constitution or under a statute is a major policy decision to be taken by the central government. It is only the central government which can take a call on this issue. Therefore, the second direction was uncalled for. As regards the third direction, the prayer was premature as when the writ petition was filed, 22nd Law Commission was not even constituted. Now it has been constituted under the notification dated 9th November 2022. We have perused the notification dated 21st February 2020, under which the central government decided to constitute 22nd Law Commission. We have carefully perused the terms of reference of the 22nd Law Commission. The terms of reference are very wide, which expect the Law Commission to make recommendations on various important aspects such as identification of obsolete laws and identification of laws which are not in harmony with the existing climate of economic liberalization. Another function is to suggest amendments to the existing laws. One of the important functions is to examine the laws which affect the poor and to carry out post audit for socio-economic legislations. Another duty entrusted to the Law Commission is to revise central acts of general importance so as to simplify them and remove anomalies, ambiguities, and inequities. Clause 9 of the said notification provides that the Commission may develop a partnership network with reputed law universities and policy research institutions in the country and abroad. Clause 10 empowers the Commission to engage legal consultants for specific projects depending on the nature and urgency. There cannot be any doubt that if such vast functions are to be discharged by the 22nd Law Commission, it will require adequate monetary support in the form of grants. Unless adequate funds are provided, the Law Commission will not be able to discharge its functions. As and when the requisition is sent by the 22nd Law Commission for requisitioning funds, the central government will have to consider the said proposal and ensure that the Law Commission does not become ineffective on account of its failure to sanction adequate funds. As regards the fifth direction, whether a nodal officer should be appointed or not is a matter to be decided by the central government. The court cannot compel the central government to appoint a nodal officer. All the departments of the government have adequate notice of the judgments of constitutional courts in which recommendations are made for the amendment of any legislation. Therefore, the fifth direction is unwarranted. The law regarding power of the writ court to issue a mandate to the legislature to legislate is well settled. No constitutional court can issue a writ of mandamus to a legislature to enact a law on a particular subject in a particular manner. The court may, at the highest, record its opinion or recommendations on the necessity of either amending the existing law or coming out with a new law. The law has been laid down in this behalf in several decisions. The only exception is where the court finds that unless a rule making power is exercised, the legislation cannot be effectively implemented. Union of India is the appellant in all these appeals, and these appeals are directed against the orders of different central administrative tribunals. The respondents are the employees of the unit run canteens, which provide canteen facilities to the troops at the unit level. Applications before the central administrative tribunals were filed by these employees claiming benefits as regular defense personnel employees or at least as civilian employees serving under the Ministry of Defense on the allegation that the unit run canteens are part of the canteen stores department, and since the canteen stores department forms a part of the government in the Ministry of Defense, there is no reason as to why the unit run canteens should not be held to be a part of Ministry of Defense. On behalf of Union of India, the jurisdiction of the tribunal was assailed on the ground that these employees cannot be held to be the government employees, and consequently the tribunal did not have the jurisdiction to entertain the applications and decide the grievances of the employees. According to the Union of India, the unit run canteens are operated by the non public funds, and the expenditure required to run the unit canteens is made out of the profits earned by the canteens itself, and therefore, so far as the personnel serving in such canteens, there is no relationship of master and servant between the government of India and the employees, and consequently, the applications before the tribunal should be rejected. The central administrative tribunals, however, at Jodhpur and Bombay took the view that the unit run canteens are the part of defense establishment, and consequently the holder of a post in the management of such canteen must be held to be connected with the defense services. The tribunals examined the relevant provisions made by different personnel providing all pervasive control with the Ministry of Defense, and thus held that there subsists master and servant relationship between the employees serving in unit run canteens and the Ministry of Defense, and therefore the tribunal retains the jurisdiction to entertain applications and decide those applications in accordance with law. The learned senior counsel appearing for the Union of India vehemently contended before us that these unit run canteens are different from the canteen stores department, and the salary of the employees serving in the unit run canteens are not paid out of the Consolidated Fund of India, but a fund created at the unit level, and profit out of sales in unit and canteens are utilized for the payment of salary as well as for creating assets of the canteens.